In this lecture we will look at Part 36 offers. You will already be familiar with the general concept of Part 36 offers. They are offers to settle a case made in accordance with the rules contained in CPR Part 36. Part 36 contains a self-contained code regarding the making and consequences of a Part 36 offer. The common law rules relating to offer and acceptance do not apply. You must look to Part 36 for the rules relating to a Part 36 offer. It is possible to make an offer outside of Part 36. The general consequences of making such an offer, if not accepted, are that the court will take offers to settle into account when exercising their general discretion as to costs under Part 44. So the learning outcomes here are to understand the principles and procedure relating to Part 36 offers, including how to make an offer. So you'll see in the notes that there are requirements about how an offer is to be made in order to satisfy Part 36 and indeed to be a Part 36 offer. Then we'll look at what happens if an offer is accepted, and there's two circumstances we need to look at. If it's accepted within what's called the relevant period, which we'll have a look at in a minute, and if it's accepted after the relevant period, or what we might call late. Then we need to look at the cost consequences at trial if an offer is not accepted. So if an offer is not accepted, what happens? Part 36 offers can be made by either the claimant or the defendant. They do not apply in the small claims track, and in order to be a Part 36 offer, the offer must comply with Part 36. For example, it must be in writing, etc., and set out certain other matters. Now there is a practice form, N242A, which you'll see in the back, in the appendix to your book. I think that's at A13. And this is a form that can be used when making a Part 36 offer. But you're not required to, and you could just draft a letter setting out your offer. However, the problem with that is you must make sure that you comply with the Part 36 requirements. And particularly when you start out, it's probably safer to use the N242A form. There have been a lot of cases about the party's failure to comply exactly with the Part 36 requirements. And I've talked about the relevant period. So the idea is that when an offer is made, a party has a period of grace, if you like, in which they're allowed to consider the offer before any consequences of failing to accept the offer kick in. So when an offer is served on a party, they must be given a period of at least 21 days in which to consider the offer before any consequences apply. And that period is called the relevant period. And the consequences are set out in Part 36, where an offer is accepted and where the offer is not accepted and beaten at trial. So where the offer is accepted, there are certain rules. If it's not accepted and it's not beaten at trial, i.e. the offer should have been accepted, then there's some quite draconian consequences set out in the rules. So firstly, looking at where an offer is accepted. So where an offer is accepted, the action is stayed. The money must be paid to the claimant within 14 days. That's within the rules, it specifies as that. And where the offer is accepted within the relevant period or on time, the claimant gets the costs to the date of acceptance. So the claimant gets all their costs. So that's the normal rules applying. Now, when the offer is accepted late or after the expiry of the relevant period, then the claimant will get their costs to the date of expiry of the relevant period. That's set out in the rules. It's a deemed cost order. And then, unless the court orders otherwise, the offeree pays the offeror's costs after the relevant period. So if the claimant makes the offer and the defendant accepts that, then the defendant's going to pay all the costs. They'll pay the cost of the date of expiry of the relevant period, and they'll pay the costs after that. However, if it's the defendant that makes the offer and the claimant accepts the offer late, the claimant will only get their costs up to the date of the expiry of the relevant period. After that date, the claimant will have to pay the defendant's costs, and that's unless the court orders otherwise, but you need a special reason to displace that rule. So there is quite serious consequences for a claimant of accepting an offer late, because they will be liable to those costs. Now, how much those costs will be depend when the relevant period expired. If the relevant period expired before proceedings are started, then the claimant will be having to pay all the costs of the claim if they accept an offer late. Now let's go on to consider about where the offer is not accepted. Now it's important when you consider about whether an offer has been accepted or not to see whether or not the offer should have been accepted. So where an offer is not beaten, so where the person who's made the offer beats the offer, then there are no consequences. So say for example, a claimant, the offeror, makes an offer to say, I'll accept £30,000. The defendant, the offeree, doesn't accept that offer. At trial, the claimant wins but is ordered to be paid £15,000 by the defendant. So the defendant, the offeree, has beaten the offer. In the case of a defendant, they beat the offer where they pay less than what the court orders. They pay less under the judgment than what the offer was. So if the defendant pays less, they've beaten the offer and there's no consequences. Likewise, if it's a defendant's offer and the defendant says, I will give you £30,000, the defendant is the offeror. The claimant, the offeree, doesn't accept that offer, and the claimant gets, say, £45,000 at trial. Now the claimant in that situation has got more than what the defendant offered, and the claimant has beaten the offer. So the claimant beats the offer by getting more than what the defendant offered. So you'll see it depends on whether it's the claimant or defendant, whether the offer is beaten. However, there are penalties imposed if the offeree fails to beat the offer. So if we look at the offer and say that in hindsight the offeree would have been better off to accept the offer, then we can say that they failed to beat the offer. The penalties only apply to the period after the relevant period expires. So before the relevant period expires, so before the offer is made and before the period of grace in which the party has to consider the offer expires, the normal rules about costs apply, and that is that costs in the discretion of the court. Let's look then at the situation where the offer is failed in a bit more detail, or what the offer is not beaten in more detail. Turning first to where we're talking about the defendant's offer. There's different situations applying depending on whether it's the defendant's offer or the claimant's offer. So let's look at the defendant's offer first and look at the situation where C fails to beat that offer, i.e. the claimant gets less than what the defendant offered, or as the rules put it, the claimant fails to obtain a more advantageous judgment than the defendant's offer. So in that situation, C should have accepted, didn't, and will be penalised for not having done so. And the penalty is basically that the claimant pays the defendant's costs for the period after the expiry of the relevant period, as well as interest on those costs. So normally, provided C gets something, the defendant's going to pay the claimant's costs under the general rules. Here, the penalty is that the claimant pays the defendant's costs. So not only does the claimant not get their costs paid by D, but worse than that, they have to pay D's, the defendant's costs. For the period prior to this, normal rules apply. So provided C has won something, the defendant will pay the claimant's costs on the standard basis to the end of the relevant period. Is the general exercise of discretion. Putting this diagrammatically, we've got this here. If you want to have a bit more consideration of this, then just pause the tape. Just to say though, the expiry of the relevant period is obviously key here. The relevant period could have expired before proceedings had commenced, in which case, as we've seen, the claimant will be paying the whole of the costs of the proceedings, even though they ultimately win something. Turning now to look at the claimant's offer. If the claimant beats their own offer, i.e. if the claimant gets more than their own offer, or to put it another way, the defendant is ordered to pay more than the claimant's offer, or as the rules say, judgment against the claimant is least as advantageous to the defendant as the claimant's offer, then unless it is unjust, for the period after the relevant period expires, D pays C's costs on an indemnity basis. So D would normally be paying C's costs, so the penalty is to pay them on an indemnity basis. However, that may not necessarily increase the cost that much. So in addition, there's 3/3 of the penalties. One is that interest on costs is payable. There's also enhanced interest on damages payable and enhanced damages. For the period prior to the expiry of the relevant period, the normal rules will apply, which is that D pays C's costs on the standard basis. And here is this expressed diagrammatically. You'll see here that the detail about the enhanced damages is that it's 10% of damages up to 500,000, or between $500,000 and $1 million. It's 5%. Now, when we're looking at an offer, we have to. So, with interest, the offer is deemed under the Civil Procedure Rules, Part 36, to include interest up to the end of the relevant period. So when comparing an offer with the judgment, you need to make a like-for-like comparison, i.e. what would the judgment have looked like at the time the offer was made, or at the time of the expiry of the relevant period. So what you need to do is you need to knock a bit of interest off the judgment to look at the period to see what it would have looked like at the time of the offer. So what you do is you compare the offer with the judgment less interest that would have accrued on the judgment since the expiry of the relevant period. So you, as I say, finally in that final bullet point, you compare the offer with the judgment less interest that would have accrued on the judgment since the expiry of the relevant period. So we've got to knock a bit of money off the judgment, but how much will depend on what period has elapsed since the expiry of the relevant period. Let's just go on to have a look at some examples. So here let's have a look at an example of the claimant's offer. So say the claimant makes a Part 36 offer of £10,000 in January. Let's look at what the consequences will be under Part 36 of acceptance and of refusal. In terms of refusal, we need to know what happens at trial. So at trial in June, we'll say that the claimant gets £15,000 plus interest. So what we can see here is, well, firstly looking at acceptance, the standard rules are that if it's accepted in time, if it's accepted within the relevant period, the action is stayed, the claimant gets the sum offered, i.e. the £10,000 within 14 days, and the claimant gets their costs up to the expiry of the relevant period, or up to the time of acceptance, I should say. So there's a stay, claimant gets their money, claimant gets their costs. Just looking at acceptance late, it's a similar situation in terms of the action is stayed and the claimant gets their money within 14 days. But after the expiry of the relevant period, the claimant will have to pay the defendant's costs unless the court orders otherwise. So there's a penalty there for acceptance late. If it's refused, then what we can see here is that the claimant is getting more than their offer. So the defendant should have accepted the claimant's offer. The defendant should have accepted the claimant's offer. They would have only had to fork out £10,000 in January. In June, they're having to fork out £15,000. Now, we'd have to knock a bit of interest off that. Well, actually, it's plus interest. But in any event, we can see that clearly, it was only 6 months ago, the defendant should have accepted the offer in hindsight. So, D has to be penalised. And the penalty for D is they pay costs on the indemnity basis for the period after the expiry of the relevant period. They pay interest on costs, enhanced interest on damages, and enhanced damages. Now, we saw enhanced interest on damages was 10% if the damages are under £500,000. So here the enhanced damages would be £1,500. Let's go on to look then at the defendant's offer. So let's look at D making a Part 36 offer of £80,000. Also, the offer is not accepted, and the claimant is awarded £75,000 at trial. Sorry, you may need to add, I think, a zero I missed out on your slides. So the claimant is awarded £70,000, including interest at trial. Now here, we can say that the claimant should have accepted the defendant's offer. The claimant's got £75,000 at trial, but they were offered £80,000 a little while ago. They clearly should have accepted that sum. They'd have been better off if they'd accepted it. Therefore, they need to be penalised, and the penalty for the claimant is, after the expiry of the relevant period, they have to pay the defendant's costs and interest on those costs. For the period prior to the expiry of the relevant period, the defendant is normally going to have to pay the claimant's costs on the standard basis. So the defendant will be paying the costs up to the expiry of the relevant period normally, and then the claimant will pay the costs after that. That's sometimes called a split order for costs. Just in terms of tactics, obviously it's quite a powerful tool we've seen, Part 36 offers. And it's important that the claimant and the defendant consider making an offer. They may decide not to, but you should always think about it and whether it's expeditious to do so. And also you should make the offer as soon as possible. As soon as you're in a position to assess your claim, then make the offer, because as we've seen, the consequences of the offer, well, firstly, if it's accepted, you want to settle as soon as you can anyway before costs are incurred. If it's not accepted, then you'll get the benefits of Part 36 only for the period after the expiry of the relevant period. Now, you've got to pitch the offer right. It's obviously got to be an offer that you or your client is, happy to accept. Happy, perhaps in quotation marks. They're going to be content to have that amount of money in settlement of their claim. And also, it can't be so low that the other party fails to beat it, because otherwise the cost consequences aren't going to kick in. Always keep offers under review, because it might be that as the evidence comes out, your case is strengthened or weakened, and you might want to either withdraw an offer because you think you're going to get more than that amount now, or you're less at risk on litigation, or you want to make an increased offer as appropriate. So maybe it turns out that the other party, in a personal injury case, for example, the claimant's injuries are more serious than they first appeared. And finally, you've got the option of making an offer outside Part 36, where you're not constrained by the rules in Part 36 about how to make the offer. So you might want to do that. So we've looked at how to make an offer briefly. There's more on that in your notes, but as I say, it's best to use the N242A form. We've looked at accepting within the relevant period and late, and the cost consequences at trial of non-acceptance of the offer. So the important thing here is to think about whether or not a party should be penalised, and then it's simply a matter of looking at the penalties that apply, whether it's the claimant or defendant that needs to be penalised.